state argues that that's too broad, where your claim is an as-applied claim only as to your two clients.
It is not as applied only as to my clients. It is as applied as the person's charged with a felony but not convicted. That is an as-applied challenge as well.
That's just some of the debates at the Illinois Supreme Court yesterday, and that was Attorney Thomas Magg responding to a question from Illinois Supreme Court Chief Justice Mary Jane Teese, and the case has the question of whether or not somebody who's merely charged with the felony, not convicted, should have their FOID card revoked or suspended. That was the question in front of the Illinois Supreme Court yesterday. I'm Greg Bishop. Thanks for joining me. Bishop on Air. We talked about this yesterday just in the overview of looking at one of the briefs, and the brief really just spelled out the question at hand. Nature of the case. This is Davis versus the Firearm Owner Identification Card Bureau at the State Police. It says plaintiffs are charged with recklessly endangering the safety of others by repeatedly shooting a semi-automatic rifle into the air, a felony offense. Now, the background of this story is they weren't in some densely urban area. They weren't, committing a additional crime like, going into a liquor store or anything like that. It was July 3rd, 2016. The Davises went outside and, some people do pots and pans, others, and it's not smart. And everybody who knows much about firearm safety will say never shoot a gun into the air, but that's what they did. Law enforcement approached them, and next thing comes, you get a indictment. You get a felony indictment. They get charged with a felony. But a year later, they pleaded down to misdemeanors. But in that year time, from when they were charged to when they pleaded guilty to a misdemeanor, that year time, their firearm owner identification card was suspended. They got it back after they pleaded to the misdemeanor, but during that year time, it was suspended. So the challenge is that legit? Can somebody who's merely charged with a crime lose their rights? Because listen, you're innocent until proven guilty in this country, right? Even the no cash bail provision that Illinois has statewide, critique it all you want, throw all the criticism that you want at it, but the supporters of it say you're innocent until proven guilty. Therefore, you should not have to languish behind bars of a county jail if you can't afford to bail yourself out. So, this idea of innocent until proven guilty, and should you lose your rights if indeed you face a felony? Well, they get into some of the nitty-gritty details here in the case as it was heard yesterday at the Illinois Supreme Court here in Springfield. And here's Lee Janig. She is the Illinois Assistant Attorney General, presenting the first bit of oral arguments in front of the Illinois Supreme Court yesterday.
Prepared to proceed.
Yes, Your Honor. Good morning, and may it please the Court. I'm Assistant Attorney General Lee Janig for the appellant, Chief of the Firearm Services Bureau of the Illinois State Police. This court should reverse the circuit court's judgment because the plaintiffs lacked standing to bring this challenge to Section 8N of the FOID Card Act. The court can reverse on this threshold basis, which goes to the case's justiciability, and it need not reach any other issue.
So she went on to talk about how the case is moot, and the challenge that the lower court ultimately agreed with, and said that it doesn't just apply to these two individuals. The entirety of the state's FOID card law, which says that you can't you have to take somebody's FOID card away if they're charged with a felony. They essentially said that can't happen, and more from Lee Janig.
There's good reason for that, because what mootness exceptions do is they allow courts to address what was once a live controversy. So if they had brought their lawsuit while their FOID cards were revoked, and then that issue became moot. But to apply those exceptions to standing would mean that courts could issue opinions even when there had never been a live controversy. And that's sort of the very definition of an advisory opinion, which this court has repeatedly said is not permitted.
So again, the idea of it being moot and them not having standing because they did get their FOID card back, but they were kind of going back and retroactively suing and So you can see how, again, if you're not an attorney, you hear these words of moot and standing and what does it mean, and we'll just kind of just let that be there. But she makes clear what exactly the question was from the lower court that the Illinois Supreme Court has to deal with.
So plaintiffs say that they're bringing an as-applied challenge, which would be a challenge to the statute as applied to them only. That's what an as-applied challenge is. But the circuit court held that the statute was unconstitutional with respect to every person charged with a felony.
So again, the circuit court found that the statute was unconstitutional as applied to everyone, not just the Davises. Thomas Magg, somebody that we've talked to quite a bit, has his hands full with all kinds of Second Amendment cases, including in the federal court, Southern District of Illinois, where we're still anticipating more filings and more things to progress to possibly see a a bench trial come sometime in July of this year, challenging the state's gun and magazine ban. But Mag also has this case in front of the Illinois Supreme Court dealing with whether or not people who are merely charged with felonies, not convicted, should have their FOID card taken away.
But for anyone in the state of Illinois who is charged with a felony,
Yes,
this injunction would sweep them all in, right?
I agree with that.
Okay. The state argues that that's too broad, where your claim is an as-applied claim only as to your two clients.
It is not as applied only as to my clients. It is as applied as the person's charged with a felony but not convicted. That is an as-applied challenge as well.
It's interesting. So what is exactly as applied versus facial, right? Because we've had this conversation before in the past, and maybe it's worth having again. Facial challenge is saying, hey, on its face, this law is unconstitutional. On its face, without it being applied to anybody. On its face, it's unconstitutional. Again, I'm not an attorney, just a reporter who digests a lot of this stuff all day, every day. So as applied on the face, or facial versus as applied. So facial, again, on its face, it's unconstitutional. As applied is, well, you've got this particular circumstance, and the law as applied to that particular circumstance is unconstitutional. So maybe it's not unconstitutional as applied to a totally different circumstance, but as to this circumstance, as applied, it's unconstitutional. Those are kind of my understandings of the two different, when you hear a facial challenge versus an as-applied challenge. So Mag is essentially saying that, it's as applied to these two individuals, but he also says it's as applied to anybody who gets charged with a felony but not convicted of a felony. But then they get into some of the nitty-gritty details about, well, what kinds of regulations are there for people who are charged with crimes when it comes to their rights to access firearms?
Isn't that what the court ordered in the
No, it
injunction?
didn't. For instance, it's a violation of federal law for a person convicted of a misdemeanor crime of domestic violence to possess a firearm, or a person adjudicated a sufficient degree of mental incompetence to possess a firearm. This same statute would require the state police to revoke that person's FOID card. That, as applied to those scenarios and every other potential scenario other than merely being charged with a felony, the statute remains in full force and effect.
Again, some of the back and forth.
But more importantly, a person is merely charged with a crime, whatever that crime is. I agree that the court, in an appropriate circumstance, following some sort of hearing, could impose certain conditions. For instance, if John Dillinger, historical bandit, were arrested and bond was allowed, I think the court, following a hearing with sufficient evidentiary information, could impose a restriction on firearms. But that's not this case. This is an ipso facto, you've been charged, therefore your rights are eviscerated case, at least for the foreseeable future. And there is no precedent in the historical American jurisprudence until the mid to late 20th century for anything coming close to that.
So Mag kind of setting up the various circumstances that there could be, how the law should be applied in his opinion, and so on. More about the statutes that he's pointing to in all of this?
There is a federal statute, 18 U.S.C. 922, N as in Nancy, I believe it's the exact quote, that prohibits persons charged but not convicted of felonies, not from possessing firearms. They can keep the ones they've got while they're under indictment or information, but prevents them from acquiring new firearms while they're under charge. That is what this case is about, is the state police interprets, and I think it's a reasonable interpretation of the statute, aside from constitutionality issues, that triggers the section N of the FOID Card Act, which requires suspension of FOID cards when a person cannot acquire a firearm.
So again, the difference that he's arguing in front of the court is that, yes, there's some statutes that say that if you're charged with something, you can't go out and buy an additional firearm, but you can still possess the ones you have. So interesting to again, get into the weeds a bit of this argument in front of the Illinois Supreme Court. So if you're not familiar with how these oral arguments go, the appellant goes first, then the respondent goes second, and then you get the appellant coming back up for some rebuttal. So the Assistant Attorney General yesterday wrapping up some of her arguments.
The Supreme Court is clear that the Second Amendment covers possession of firearms for self-defense by those considered law-abiding and responsible and not dangerous. This does not cover the plaintiffs because while they were under this felony charge, they had conceded that there was probable cause that they recklessly endangered others with firearms. So that would sort of suggest that shows that their claim would fail at the first step.
So ultimately, the Assistant Attorney General asked for the Illinois Supreme Court to reverse the lower court's decision in this particular case. And here's the final comments.
That still sort of raises the questions of, the way that we kind of know that this is a standing case instead of a mootness case is that we sort of ask, well, when did the issue become moot? When was there a live controversy? And the answer is there never was, because the plaintiffs, the issue was kind of moot from the beginning, for one way to put it.
So interesting, again, something I think that we'll see what happens when the Illinois Supreme Court actually rules on this case. This is one case that they've heard. They've got a case they heard last week that dealt with unlawful possession, or rather unlawful use of a firearm, and what exactly constitutes unlawful use of a firearm. I'll see if I can go back and grab some of those details later and try to review that. But they do have an interesting case coming up this morning. It doesn't deal with firearms, but what it does deal with is whether or not healthcare institutions had immunity during COVID-19 emergency orders. So we may have to touch on that tomorrow, which is kind of fascinating. All right. It is Bishop on Air. Appreciate you guys being here each and every weekday morning.